Here together with the assistant deputy for state. I will look at this as well.
My name is Samuel. This is in English. Here is going to be language for Chile. The language in a folk. Very fancy.
It's someone they're reading. Very good. Hi. Your case number 01966. One of the study with recycling, and managing unlawful society, contrary section 53 of the Penal Code. Prosecution raised a criminal issue for court to issue an in-court protective measure to avoid life discrimination. In support of this application, the learned counsel with the government leading the prosecution team relied on Article 28.2 of the 1995 Constitution, submitted that though the Constitution provides for public hearing and fair court, nothing shall prevent the court from excluding the public from all or any proceedings before it for reasons of morality, public order, national security, as may be necessary for a free and democratic society. The prosecution went ahead and relied on the aspect of public order and national security. Prosecution submitted that charges against the accused person are inciting violence and managing unlawful society, and previous it was accused charges of terrorism, which cases are still ongoing. Further, prosecution submitted cases that these cases involve matters of public safety, like the compromise witness safety, exposing cases to intimidation, and influence the public in a manner prejudicial. The prosecution further submitted that exclusion of media does not involve on the accused's constitutional right to a fair hearing, but rather ensures that the trial or court proceedings proceeds in a manner that balances the preservation of public order, national security, and integrity of the judicial process. In response, the Learned Counsel made a seminar referred to Article 21, Article 28 plus 1 of the Constitution. It brought this application in a casual manner without formal application, with no supporting evidence. As a subject that the right to a fair hearing is a guaranteed right, and referred to Articles 28.1, 28.2, 43.1, and 43.1, and 42, 43.2. That matters of national security cannot be speculated in terms of a particular witness or this control. Because speculated that witnesses may be intimidated. Also submitted that the burden of proof to justify this application lies on the state established proportionality and minimal impairment of the right to accuse the public hearing. Reference was made to the cases of Charles Onyango versus the Attorney General Constitutional Application number 2 of 2002, and specific reference was made to the judgment of Sekoko at page 7. Further, the council made that submitted that Section 14 of the ACA provides the power to give orders for the exclusion of the public or a particular person not to have access to the courtroom with justification. The standard provision must be construed in a manner consistent with the Constitution as provided under Section 2. This council made a single submission that major offenses like the minister cannot be used as a valid deny public access. The referred Section 41 of the Access to Information Act. Several authorities were supported in support of their agenda. In response, the state emphasized their initial position of seeking an import protective measure against live streaming. They submitted to compromise the proceedings prejudicial to fair administration of justice. Further submitted that the state did not record a closely trial in camera proceedings, but rather sought to reflect a particular mode of live streaming of proceedings because they present distinctness to the trial integrity of the proceedings and other administration of justice. What the defense has done, they have raised their own issue in reference to the closely trial in camera proceedings. They have made reference to text application not being formalified. They have not given the law on formality. No law backs or application in a matter of this nature. State referred to Article 126 of the Constitution that substantive constitution administered without undue regard to technicalities. Other states submitted that Article 281 of the Constitution does not guarantee the right that the constitutional guarantee of a public hearing does not provide an automatic right to live streaming. The distinction between public access to court proceedings and live transmission of proceedings is very important. Court's analysis. Court looked at Article 28(1) of the Constitution that guarantees public hearing. However, the right to public hearing does not create an automatic right to record, broadcast, live stream proceedings. Section 40 of the Magistrates' Code gives the power to the court to control the manner in which proceedings are conducted, subject to the Constitution and the law. Cameras and phones may therefore be permitted in court by the need of the presiding and subject to conditions of the judicial system is appropriate. The judicial officer presiding over the matter is responsible for maintaining orderly conduct and dignity of the proceedings. The judicature electronic typing service and virtual proceedings rules 2025 also requires the use of technology in the proceedings. Specifically transmitted to Rule 6.1, which requires the approval of the presiding officer before technology is used in court. While the present court does not have an electronic recording system, and therefore there is no official electronic court recording, to which computing recordings can be compared, the underlying principle remains relevant. The use of technology in court is subject to control and approval of the presiding official. Open justice means that public may ordinarily attend and observe proceedings. It does not necessarily mean that proceedings must be broadcasted live. Court has to balance the legitimate interest transparency, public access, against the court's overriding responsibility to ensure a fair, orderly, and dignified hearing. The court has taken into consideration the submissions of both members of the council. The law hereby orders that the application succeeds. Hearing of both bail and trial shall remain open to the public and accredited members of the meeting. Live audio recording, live video, live streaming from inside the courtroom is prohibited. Clear, accurate, text-based reporting of proceedings had in open court is permitted, subject to the content, to the law of content and the rule of sub judice. Media attendance is subject to court verification by a court administration, not as a device of exclusion, but for order, space management, and security. All counsel, parties, supporters, bloggers, journalists, and members of the public are directed to refrain from the commenting on the merits of this case before the conclusion of this. I hereby counsel. We have a pending application from the bench. You will have it. For us to listen to the application. We filed a written response to the application. The total. Your Worship, the respondent objects to the application for bail and claims that the applicant be denied bail. We rely on the affidavit of Detective Corporal of Police, Mukwezi Abai.
No secret evidence. It's as they are notified the state. Within reply. It follows that we are entitled right to respond. The reply. I will be joining them. The appearance of data and static submissions. Right. 4 hours is on record. Secret narratives. Anita's. How are you doing that? Given the written then, adequately and effectively. Yes, we can do in one day. The neighbor is going to be expedited. See, in one day, more than at least 25 by Thursday.
You find the urinate on the hard day.
Well, actually, the reason why we wanted that is because we're going to be at the same time. By tomorrow, and by today, because of the morning. That's it. Getting the submission. Yes.
We start the written
Well, maybe let's speak the education. Say speaks in two things. After that, you break one time within something. What you start, well, nothing to I did something.
we start transport, right? For example. So we start them with the database and also the respondents. We start.
The needs.
Like what?
Yeah, they have one. So, does that mean that it's also going to be like or in addition to grading, or we just respond to this? So that you have to respond. Yeah, because you know, when you're reading something, you don't have to so to respond.
You're right. You seek the permission. No, once you state that you do not have it, I think it's sufficient. So the way we simulate our jurisdiction now, one from this. Understand? State, right? By 27, we are by post. Yeah. Right.
Hasa mwanzo kumulira kutebenga okunsala omupaka bamwenyumira obanyiga n'ekirala kokyeganya kukwata butereevu kugenda amaaso mu kkooti naye negaanye okubaako kugoberera mu kkooti wekyalire mu kujja mu kkooti
Nena microphone yangu. Microphone yetu.
Ekifaananyi kiri kimu.
When on board again, wali wenyini wakati kuna sawa.
Yes, oludda oluwaabi lwa gavumenti yasaba okugalira ebweru live streaming mu kkooti agamba nti waliwo abajulizi abatali sikiwa na nsonga eyo. Tugenza okutunuulira abajulizi abo be boogerako nga bonna abapoliisi. Ekitegeeza babadde basaba kuprotectinga abapoliisi omuli SP Bananywa, omuli AIP Akampulira n'omuli Kopolo Omota. Kyabo kyabulabe nnyo mu kubanga mu live streaminga abajulizi abo kyabulabe gye bali. Abapoliisi bali bokka abajja mu disclosure ne tukiwakanya
nga tugamba okuprotectinga security y'aba security ng'ojjawo eddembe lya constitution erya munnayuganda lyali yenna okuba ng'agoberera proceedings zino ekiri mu mateeka. Kooti yo egambye nti ekkiriza okusaba okwo ate ke bagenda bakkiriza kugenda mu maaso nakuweereza butereevu bigenda mu maaso mu kooti eno. Okuwakanya kwaffe twakusimbuliza mu constitution nga tugamba nti akawaayiro ke boogerako kagamba olina okubeera ne gye bayita public hearing. Speedy, fair and public hearing. Kati ebyo byonna ebisatu bw'oba wakukijjawo oba kikugira ekya constitution olina okujja n'obujulizi obulaga lwaki okijjawo. Tebaleeta bujulizi bulaga nti aba security abaagala kooti ebasekiwalinge waliwo embeera yali bateereddwako ejjawo obutebenkevu bwa poliisi abo. Naye nga bw'eri kooti ekiragiro kyayo ekiwadde ekizibu kyekoze ekitadde ku bannamawulire n'ekituusa ne kwabo ne bataasaba. Omwabi wa gavumenti teyagambako nti balooya baggala emimwa. Kooti esazeewo evudde mu kusekiwalinga bali oba naffe tuli babulabe eri abapoliisi abo abajulizi bokka abasatu abali mu musango guno. Egaanye n'abantu bonna okwogera ku nsonga zino. Kirungi kyetaddemu nga zikyali mu maaso gaayo. En application gye twogerako kaakati egoli bannamawulire tekyali mu maaso ga kooti eno. Era muli baddembe ogyogerako kuba yo fayiro eggaliddwawo. Era tugyogerako lwakuba tugiwakanya. Kooti tugiwa ekitiibwa naye tulina obuyinza obugiwakanya mu mateeka. Eno kooti tugenda giwakanya ku nsonga eyo. Ekisooka kooti terina buyinza buziba mimwa gya bannamateeka mulimu obwafu gwakwogera. Eno ensala tugenda gitwala mu maaso ng'ekitongole kya bannamateeka oluva wano kati. Eno ensala etali mu mateeka etandikira mu kitongole kya bannamateeka mu society. Awo bwana abalamuzi nabo balooya twabo bakyagwanidde okuba nti nno atambuza ensonga z'amateeka. Ekyokubiri tufunye instructions okujulira ku nsonga eno kubanga kano kagenderere ng'omukadde akola ki okga nti ekikoleddwa wano takiwakanya kyatandika mpola ne kitandikira ekawempe. Decision y'ekawempe yennyini wano omuwaabi wa gavumenti yanoonya omusango ogwali gubadde mu mbeera efaanana bw'eti mu kooti ejulirwamu oba kooti eya rekodi ate guliiyo. Wano yaleese musango gwawa gw'ekawempe ogwa kooti eri ku level emu n'eno. Ekyo nakyo mu mateeka si kituufu. Era bwe tutunuulira ensala eno ne tunulira n'omulamuzi wa kooti ente eri tebaawukanye. Ekitwewuunyisa kiri kimu nti kooti enkulu eziwuliriza emisango gy'obutujju ez'okulyamu ensi olukwe tezinagaana bannamawulire kwewuunya omusango gw'olukuŋŋaana olwali mu maka g'omubaka gwe gw'obulabe ennyo eri abo abajulizi aba poliisi. So mwe tugenda okusimbuliza okuwakanyibwa nga twerwanako tugenda kulwanira eddembe lya bannamawulire. Agita tagiwoomya tugenda naffe kwerwanako. Tugenda kulwanira eddembe lya bannamateeka. Kooti beegambye nabo balina okusirika. Tugenda kulwanira eddembe lya bannayuganda. Ekigenda ky'okugamba nti erina kuba public hearing kya transparency. Kiki ky'okweka? Okweka live streaming bakugamba ko tulina okusalawo otunuza kamera. Ko tusalawo ani ayingira kooti. Ekyo tebalina mateeka we bakisimbuliza tugenda kiwakanya. Tugenda kugenda mu maaso n'okuleeza omubaka nga tusaba kiri kimu okwewala obusambatuko bwonna bwonna. Ndoza kiri mu mateeka okugenda mu maaso nga tugenda ku ekyo kyatuleeta wano oleza mu mateeka n'omusabira okweyimirira mu mateeka era kooti ekisazeewo nti no ng'ennaku z'omwezi 3 egenda tuwa ensala yaayo inajja wano obutali butebenkevu oba buli gyakoma okubeera mu kkomera ndowooza ne mu kooti eyo obutebenkevu bwe bubeerawo so tufunye instructions ezo tugenda ze executinga naye oluva wano tugenda mu ULS mulindire ekiwandiiko kyaffe wa mu Uganda Law Society walina ensonga tetwali bawawaabirwa naye ate ffe abatali bawawaabirwa kooti naffe tutaddemu waabwe beetaddeko ekiragiro kiri wabweru w'amateeka ekyo. Yes, the state, the DPP made a preliminary objection or issue, whatever they called it, seeking for orders of this honorable court to close out live streaming media from the proceedings of this honorable court. Well, we opposed the application because we thought it was really unconstitutional, especially if it's without any evidence of the threats that were raised. The state's contention is that such orders were intended to protect ASP Bananywa, to protect AIP Akamprira and Corporal Omota Julius, who were all police officers. So they sought an order to protect witnesses for security. Security witnesses sought to be secured by the court, and that order has been granted. Of course, in as much as we respect court, we have the right to disagree with the decision of court. Court has gone ahead to make gagging orders, not only against whom against the orders that the state sought. It went outside the prayers made by the state. It went ahead to gag counsel in this matter and all and sundry, the public at large. We thought this was outside the purview of this application. It was without basis that such orders, keeping orders against counsel were made. Ours is simple. We are going to reject this decision through lawful means. Right from here, we are going to look for means of reviewing this decision in higher courts. This decision, though not of the court of record, is now setting a pace and a pattern. It started in Kawempe Kanyanya, where grade 1 magistrate made the same orders. When we came into this application, they could not cite any decision of higher courts but that of the grade 1 in Kanyanya. How can that even persuade this court? If you read the decision of Kanyanya and this one, they are similar in nature. So we believe it is unconstitutional, and courts should not close out the media. Closing out the media is closing out the public. Article 28 is very clear. The accused are entitled to a fair, speedy, and public trial. So if you have to close out the public trial, it has to be with the basis. So it is on those grounds that we are going to challenge this decision and reject it through the Uganda Law Society. Right from here, we are going directly to make a decision about this contemptible decision of this court. Well aware, if there are any threats, probably it is caused by keeping the Hon MUWANGA KIVUMBI here. Maybe through the bail application we made, that fear may be allayed by granting him bail. We are coming back here to court on the 3rd of September with a view to obtaining bail. What will stop this court from granting bail to a person who has bail from a specialized division of the High Court in IC.
They prolonged the
detention of the Honorable Mwanga Kivumbi and denying them their constitutional right to play. It's very sickening to some of them. And this prolonged delay to grant him bail is deliberate because I think it is intended to punish him. It is a pre-conviction punishment to the Honorable Mwanga Kivumbi. But mine is to thank the legal team. It is good that they now know they actually know their rights and the rights of the media. And they are putting up a special fight to resist the carrying of the media and that of the lawyers. I must salute them for planning to appeal to the law council and other avenues of redress. But now it becomes very clear about the fundamental magazine, the legal magazine that says that just delayed is just denied. Here, the delay literally means we are denying and now they are pushed against the here. The ruling actually, the ruling on 3rd September next month. Even we are not very sure, we highly doubt whether again it will come to pass because we are moving around in circles and circles. It is sickening. Uganda, the Japanese are Peter Buffett, what are doing better what in higher levels of redress. And then in Korea, everyone present over Mahidi. Ukagala kusalawo mangu kweyibirirwa bali Honorable Mwanga Kivumbi okuba ffenna baali baagala kweyibirirwa bwetuli era buli kanaku tujja naye laba ate basimba batusindize mu maaso 3 Septemba omwezi gujja natujja okukomawo twebaza abapiida baffe teekawo. Well, I think ensala kooti tetukanye nayo ate nga ddembe gyaffe okuwakanya kooti. Yes, tugiwa ekitiibwa nga kooti eddembe ebange nga bannamateeka okugamba nti ensala tetukanye nakyo ddembe gyaffe. Kati kino kyebatukozeewo ekyokugoba abamawulire mu ntuula za kooti tukikiriziganye nayo era mujjukira byatandikira Kawempe baba balina bye baagala okulya okukweka okugoba bannamawulire. Ate kooti erina okukimanyi nti bw'ogamba nti bannamawulire kamera zammwe esigale ebweru naye muyingire just ne kapeeni n'akapapula w'okuwandiika. Ekyo ne kooti kiba tekikikolera kubanga kati munnamawulire bw'anaawandiika ebitali bituufu batakuwulidde bulungi naki talina reference ya recording ajja kutunulako omulamuzi yayogedde bw'ati state yayogedde bw'ati kati awandiika ebiwandiisi byawulira oluusi boogera akola kakati eventually bw'anaateeka binaga nti omulamuzi yayogedde bw'ati state yayogedde bw'ati ng'oba oliawo waliwo byatawulidde onoomunenya wakati gwe omuganya okuyingiza kamera zandibadde zikwata buli kimu bw'aba alina kyatawulidde bw'anaddayo gy'akolera nga azannya akatambi ako n'awulira obulungi. Kati kooti kino simanyi nabaani abazibwabula kuba kino nabo ekibakolera. Omulamuzi of course agambye nti fenna bannamawulire n'amateeka abaani abakwogera ku nsonga ezikwata ku musango guno ekyo naffe tukimanyi nga bannamateeka waliwo etteeka erya subjudice naye subjudice tetugaana kwogera ku bigenda maaso mu ggwanga politics eyeekuusa ku misango nga gino Ibyo tewali tteeka litugaana kubyogerako nti n'omusango gwa byabufuzi. Tewali nsonga ndala yonna gwa byabufuzi. Tuzze tumanya ntugamba abantu abattibwa mu maka g'Hon Muwanga Kivumbi teri aboogerako. Tetukyabanja abantu abo muvunaana Hon Muwanga Kivumbi n'abalala. Manya baayogera bwe bati n'ebirala bwe bityo abatta abantu abo baliwo. Ezo ensonga tugenda kusirika okwogerako era kkooti terina lukusa kutugamba nti ebyo tebyogerako. Kisoboka ddala. We have, yes, had the ruling of court. We obviously do not agree with it. We find it to be a very problematic ruling. And you see, when court says that the media should be thrown out, they should have no access to their gadgets and so on, that matter began in Kawempe. It's very problematic. The same as happened to me. It's not even good for court. I don't know who advises this court. Because when you tell journalists that you only enter with a piece of paper and a pen, right? Don't enter with gadgets. What happens if this journalist does not clearly hear what the judicial officer said, what the prosecutor said, because they are scribbling away? And then they misquote you. Who will you blame? But when there is a recording, these journalists will go back to their newsroom, and what they didn't hear properly, they will play back this recording so that they properly quote the judicial officer for the state prosecutor. For some reason, they decided to do this way. I don't know where they get that from. Anyhow, the other ruling, of course, was not a ruling, but court was wanting to say, yeah, the sub judice rule does not allow journalists, us, and even lawyers to talk about the merits of this case. We know that, of course, as lawyers, but the sub judice rule does not stop us from talking about political undertones and the situations happening in this country. It does not. For example, to say that this matter here is not a legal matter, it's a political matter. For us to demand and say that before I think that Hon Muwanga Kivumbi, we demand for justice for them. We shall not stop talking about it.
But even the subjudice, we cannot speculate that way. Subjudice comes after. And the court, we cannot.
Thank you. Swabla. Swabla.
Ensala ya kkooti
Gwe mpola kyonyigiriza.
Omanyi bwe baba bakuleseeko.